Welcome to the Volunteer and Combination Officer section webinar on discrimination, harassment, and retaliation in volunteer staff departments. This is a different kind of topic that many fire and public safety personnel don't want to talk about or don't want to learn about. So we're extremely excited today to have a very knowledgeable presenter who's going to share some of her experiences and help us understand how to not get ourselves in trouble. The program is voice over IP technology, just like every one of ours. If you need support, go to the chat room. I'll be monitoring the chat room, or you can email webinars@ifc.org and we will try to help you get fixed. But I will tell you, if your system locks up, log off, log back in. We've had that happen. It happens to me, and it might happen to the presenter. But we will handle it if it happens to the presenter. But that's my best technology advice to somebody whose system locks up. Question and answers and chat. Chat will go on as throughout the presentation. We'll be monitoring the question and answers. We will not interrupt the presenter unless it's somebody says, I absolutely don't understand what she said. So keep that in mind. And then handouts, the presentation will be available in the handout section. What is the VCOS doing? Well, I think, I'm sort of prejudiced in favor of the VCOS since, I've been a member since we started in 1994. But one of the big things is Symposium in the Sun, where 600 of our friends come together every November at Clearwater Beach at the Hilton Resort to learn over 4 days of education. If you've not ever attended it, I encourage you to attend it. But I also encourage you better hurry up and register as soon as registration opens up in April, because it's been sold out for 8 years. All the other things on the screen there are things that we do. I'm not going to read those to you. You can read that stuff. But we are a pretty active group of members. We have the weekly webinar series, and this week we have two. But and many times we have one every Tuesday afternoon at 4 p.m. Various ribbon reports on various topics are available free of charge, whether you're a member or whether you're not a member. And so I encourage you to go to the vcos.org website, and you can download any of these ribbon reports. Here are some of the upcoming events and what we're doing from the webinar series on the left, and then other IFC events over on the right. If you've not ever attended Fire Rescue Med, it's a great conference that's being brought back live. It has been virtual for several years, and so I encourage you to look at Fire Rescue Med topics and see how they might be of interest to you. So, our topic for today, Introduction to Discrimination, Harassment, and Retaliation. Alyssa Arnoff is our presenter today. She is an attorney from the Chicago area. She is I'd say she's an expert in personnel and employment law. She's been working in the fire service since 2010. She has learned what blue card is and what a truss is. So with that, Alyssa, I will turn it over to you. The floor is yours.
Okay. Thanks, Chief, and thanks everybody for joining us. I'm going to go through some basic and some specific things regarding discrimination, harassment, and retaliation, which will also include some of the new laws that you've got to contend with. What I want to start out with whenever I'm speaking with people from either a volunteer or combination department is we always have this issue come up, do the employment laws really apply to us? And I always work from the assumption that the employment laws do apply. They do apply to you when you're talking about your planning and how you're addressing personnel issues, because ultimately an arbitrator or a judge or a jury are going to be the ones that tell you down the line whether you're covered. So from a practical standpoint, it makes sense to follow the laws to the extent that you can, so we don't have to worry about that at the other end. So again, what I want to talk about today is discrimination, harassment, and retaliation. And the reason the circles interlock is because they all do relate to one another. Something that the Chief and I talked about before, again, this is not a DEI program. It's not a diversity, equity, and inclusion program. When we talk about discrimination, harassment, and retaliation, obviously your policies and how you address these issues do influence DEI, but we're really talking about what your legal obligations are and to give you best practices in personnel management, so you're not dealing with charges or complaints. So the first law that I want to talk about, and you probably know of it, is Title VII. It's fully called Title VII of the Civil Rights Act. And it's one of the oldest of our civil rights laws, and it covers 3 different areas. It covers sex or gender. It covers race, color, religion, or national origin. Depending on where you live, you may have a state law that covers these things as well. So for example, I'm in Illinois, we have the Illinois Human Rights Act. If you're listening from California, you have the California Fair Employment and Housing Act. If you're in Connecticut, you've got the Connecticut Fair Employment Practices Act. So in addition to the federal law, you may have a state or municipal law that talks about the same things. And basically what this law says is you cannot treat anybody different on the basis of their gender, their race, their color, their religion, or their national origin. And I want to talk a little bit in detail about each of these means as we work through it. But again, under each of these, what's important to remember, under sex, race, color, religion, and national origin, 3 different types of activities are prohibited. You can't discriminate on the basis of race. You can't harass on the basis of race. You can't retaliate on the basis of race. So there's all types of different claims that can come up. So when I'm talking about these 3 things, what do I mean? How do we define them? So in the broadest terms, when I talk about employment discrimination, what I'm talking about is we're treating somebody differently due to their protected class status. And again, when we're looking under Title VII, we're looking under these 5 protected classes. Where I am in Illinois, we have other protected classes. We have arrest record, we have marital status, we have parental status. So you can't treat people differently because of their protected class status. So what might that mean, for example? You can't assign, for example, you can't assign a woman to only a day shift because you think she needs to be at home in the evening to make meals for her family. That would be a form of gender discrimination. Now, harassment is a form of discrimination. It's a subset of discrimination. And we're going to talk about it a little bit more. So there still has to be a protected class status. But here, the person is being treated adversely because of their protected class status. It creates what we call a hostile work environment. A lot of times you hear people throwing that phrase around. A lot of people use hostile work environment, and it sets off red flags in all of our heads because it has a legal meaning. But unfortunately, people use it commonplace. We want to talk about what the legal meaning is. And finally, and really the most important, and why I say that I'm still in business, is there's retaliation claims. And a retaliation claim is when something really bad happens to somebody because they've either reported or complained of discrimination or harassment, or because they were a witness or somehow helped in an investigation. A lot of times we find out later that somebody felt harassed, but they didn't report. And we always wonder, how could you not report that something terrible happened to you? And it's because you're afraid that something worse is going to happen to you if you make the report. And we'll talk about that. You don't want to be the it girl. You don't want to be, the African-American firefighter that complained about the photographs that were put up in the locker room. So, and as we'll see, I'll show you a chart. It's retaliation claims that you need to be concerned about the most, and where training is really important. So I wanted to focus a bit on gender discrimination. In most of the surveys we see, in one of the projects I've been working on with the NVFC, we just did a survey, and where most people said they had difficulties with discrimination and harassment. The number 1 complaint was gender, and the second was race. So I want to talk about gender a little bit. There's a lot of misunderstanding what gender means with respect to the law. And we have 5 different areas that the law protects. So First is when we call gender or sex. That means your gender assigned at birth. So we mean male or female. Okay? That's one form of gender discrimination. Okay? I'm going to go over to the other side where it says gender identity and expression. We have people now who identify as other than what their sex was assigned at birth. We have people who have transitioned. We have people who consider themselves non-binary. There's a whole host of categories, and that's called gender identity. And we cannot discriminate on the basis of gender identity, regardless of what you may hear in the news. And what also falls along with gender identity is gender expression. Gender expression means we can't discriminate against somebody or harass them because they don't present in the manner that we think a woman should present, for example. You've got a woman that comes in with short, spiky hair, or, is always, baggy jeans and wife beater t-shirts. And if somebody expresses themselves differently. So you cannot stereotype people. So we have gender at birth, but then we have the gender as the person perceives themselves to be. Then we have sexual orientation, which again is something completely different from gender at birth or gender identity or expression. So whether somebody is heterosexual or homosexual or bisexual or pansexual or asexual, okay? An agency cannot take adverse action or treat somebody differently because of their sexual orientation. And in fact, many of the large verdicts that we've seen in the fire service in discrimination and harassment cases have come under the ambit of sexual orientation. Pregnancy and pregnancy-related conditions fall within sex or gender discrimination. So it includes being pregnant, it includes morning sickness, it includes the time off that somebody may need to go to the doctor. You can't treat somebody differently because of that. And then finally, we have childbirth. You cannot discriminate against somebody or harass them because they've given birth or because of a related medical condition, for example, postpartum depression. So our gender discrimination and harassment covers a whole host of things. You may not have laws in your particular state or in your municipality that cover gender identity and expression and sexual orientation, but federal law does. So, when in doubt, pretend federal law applies to you. So let's talk about harassment a little bit. And we talk about discrimination again. You can't treat somebody differently because of their protected class status. Again, you can't give your Jewish probie the worst locker because he's Jewish. You can't always tell your Mexican paramedic that they're expected to bring refried beans to the company picnic. All that type of, that's discrimination. But again, remember, harassment is a form of discrimination. And we have 4 things that are required for harassment under the law. 1, we've got to have the protected class status. And we talked about sex, race, color, religion, or national origin. And you'll also see as we go on, you can't discriminate against somebody on the basis of their age or harass them on the basis of their age or on the basis of their disability. And we'll talk about that in a little bit. For something to be harassment under the law, it's got to be unwelcomed by the target. And that's something that's very muddy and is difficult to understand. So, for example, if you have a firefighter who's constantly asking another firefighter out on dates, and she accepts and goes out with him and they begin a relationship, can that be considered unwelcomed because the firefighter consented to the dates? A lot of times people put up with the harassment and appear to consent, because they think it's easier to go along than to fight it. So, for example, if you are, if you're in your firehouse and, people are telling derogatory jokes related to religion, and that you've got somebody of that faith standing there and they seem to make a joke back or they don't say anything, don't just necessarily assume that it's okay with them, that they've consented to it. A lot of time it's just easier for people just to go along to get along. The third element for something to be harassment under the law is it's got to be severe or pervasive. So again, going back to the date example, just because somebody asks somebody out once or twice, that doesn't make it harassment. It's got to be conduct that that is pervasive. If somebody asks, and I apologize, kids are coming home from school and they're yelling outside, so I'm hoping you can't hear that. It's got to be pervasive. The law doesn't tell us, however, does it mean is 5 requests for dates too much? Could it be a combination of things? Could it be 2 requests for a date, sending somebody an unwanted gift? We really don't know. And that's why, again, it's really important that we have policies in place and we make sure that people know that they've got somebody to talk to if they've got a concern. Otherwise, there are some things where it only has to happen once. So, for example, if somebody is raped, that's severe. We don't have to wait for it to happen again. I will tell you, in the 3 states governing the law where I live, we had a case many years ago where the judge read this as severe and pervasive. We had a sheriff's deputy that was raped, and the judge found there was no sexual harassment because it only happened one time. As you can imagine, that went over like a lead boot, and it went up and it got overturned. And the judge retired shortly thereafter. So something to be severe, it only has to happen once. Where we've seen some change in what the judges are doing, and this has happened in some of the cases involving the fire service, when a noose has been found in an African-American firefighter's locker, that in itself is considered severe. Probably 5, 6, 7 years ago, we would say something like that had to be pervasive, but the judges have changed their thoughts there. So depending on what it is, one time might be enough. And the fourth element for something to be unlawful harassment is that somehow the harassment has to change the terms and conditions of employment. And how might that manifest itself? The person might be afraid to come to work. They may eat by themselves during dinner. They may be slower to respond to calls. They, aren't really participating in training. They are afraid when they go out on calls that somebody's not going to have their back. So there's really got, there's got to be a change. So what I want to make sure that you understand is these are the 4 things to make something unlawful harassment. From where you stand, I never want you to have to be in a position that you've got to say, do I have all 4 of these things for it to be unlawful harassment? What I tend to try and preach and teach, if you're seeing any of these things happen, you want to make sure you're addressing it either formally or informally, because you never want to have to deal with the lawyer and deal with whether it meets the definition of illegal harassment. If something looks like a duck and walks like a duck and talks like a duck, we want to call it a duck and deal with it before it gets out of hand. So again, just another way to look at harassment. It's behavior that's humiliating. It causes distrust to the person. And it's really important that all your personnel understand that they have the right to be free from discrimination or harassment. And especially when we're looking at volunteer and combination departments, we really are reliant on the people that we can bring in and who can serve, because we're dealing with people who have other jobs, people who are retired, students who are looking to do something while they're at a nearby university. We really have a different population here, and we want to, and we want to be able to retain people and retain good people. And so we need to make sure that everybody understands there's conduct that we're not going to tolerate. Something also that's recognized under the law that a lot of people don't understand, and we've seen some of these cases and we've seen some of them in the fire service, is you can't be discriminated against because of the race, for example, of someone with whom you associate. If you've got a white firefighter dating a black firefighter, that white firefighter can't be discriminated or harassed because he's dating somebody outside of his race. So something that we need to remember. Also, it's this perspective of the target. Remember when we talked about whether the conduct was welcome or whether the conditions of employment were altered. It's really how I, as the recipient of the conduct, will feel about it. It doesn't matter whether the harasser had all good intentions or was, just joking, or, thought eyeballing me up and down and making sexual comment would make me feel good. So, it's really how I, as the target, I'm going to perceive it. And it makes it really difficult because, we kind of have to guess how people are going to feel about these things. And that's why we want to make sure that people understand that there are boundaries. And especially when you've got new people coming into the department, you don't know what their boundaries are. And we've got to, we just have to make sure that our personnel know how to treat everybody fairly so we don't end up with any of these complaints. So I talked about the federal law, and the federal agency who enforces the law is the Equal Employment Opportunity Commission. And it just kind of repeats in a more legal way with things that I've said. And, it makes clear that a woman can harass a woman, a man can harass a man. One thing that the EEOC has not updated yet, it's in its guidances, is it's not updated to recognize that people may be non-binary. It still uses the language of man or woman. I would imagine that at some point they're going to change that. Something that comes up within fire and EMS and with police as well is you can be harassed by a member of the public. The federal law does not address this. So, under federal law, would a firefighter have a cause of action if he was harassed by a member of the public and his department didn't do anything about it? Here in Illinois, where I live, if you're harassed by a third party, you can't have a cause of action. You can't have a claim if it's not addressed. One of the things that I think is really important is if you do have a member of your department being harassed, kind of a spur of the moment, do you deal with it and say something, to John Doe or to Mary Smith when it's happening? You've got to play that by ear, but you always want to make sure when you get back to the house that you're supporting your firefighter and you're making sure they've got the resources they need and that they get to vent and you hear them out. So again, just finishing up with Title VII, it covers sex, race, color, religion, or national origin. We explained sex in detail. Color, we don't see a lot of color cases. Most of the color cases that I've seen and have dealt with have come in out of the Southeast. And it has to do with, for example, whether a Black employee can pass for white and might get hired or promoted more quickly. We're not seeing a lot of those cases. The reason I now have race, religion, or national origin in green on this slide is these are the three areas under Title VII where we're seeing the most new filings. And the reasons we believe that we're seeing these filings relate to the COVID-19 crisis, where we are seeing an influx of discrimination and harassment charges filed by Asians and Pacific Islanders because somehow they're considered the cause of COVID. With respect to the war in the Middle East and the war in Ukraine, we're also seeing, again, race, religion, and national origin charges where people saying they're being treated differently or harassed at work. And at least what we're seeing here in my area is we're also seeing an increase in claims against people who are from South America, who are being harassed because of the migrant crisis, and people are taking things out on people who have been here for a number of years. So this is where we're seeing the rise in charges. So that's Title VII, and again, your state law probably has something like that as well. This is in the materials just quickly. Even a volunteer and combination department should have some sort of policy that talks about prohibiting discrimination and harassment, giving some definitions. Always give some examples. You don't need, to have 20 examples, but, you want to give some kinds of examples of what inappropriate conduct is. You've got to make clear what's going to happen if someone violates your policy. You need to have some sort of investigative process. You need to talk about reporting. And one of the important things for reporting is somebody has to have at least two choices to whom to report. And that's because you never want somebody to have to report to the harasser or the person who's discriminating against them or somebody up on their chain of command. So think about that. Is there someone else in your municipality? Is there someone in your fire district who could be a reporting source? Where we see a lot of investigations fall short is that nobody ever follows up with the complainant. So the complainant doesn't think that anything, that investigation has been done or that anything has occurred. And we're going to talk about retaliation. You want to make sure that everybody understands that you cannot retaliate against anybody for making a good faith complaint or for participating in an investigation. I stress a good faith complaint. A bad faith complaint, those are unusual. Those are complaints that are made, really maliciously. It's still a good faith complaint if you investigate and you can't determine who's credible. A lot of these cases are going to be she said, he said, or he said. If you can't make a determination, that doesn't mean it's a bad faith complaint. A bad faith complaint where I've seen them is where somebody made a bad faith complaint against a supervisor because they didn't get a promotion, or they made a complaint because somebody was dating somebody else and they wanted to get them in trouble. Those are bad faith complaints. And again, really important is we want to have training on this, and your training needs to be fire service specific. I want to turn to religion for a moment. That is also covered by Title VII. What's really important for you to know about religion? What's really important to know about religion is religion doesn't just necessarily mean Judaism, Christianity, being Hindu, being a Buddhist, being Greek Orthodox. It's so much broader than that. It covers, any standard of belief that a person truly professes to believe in and live by. So to the extent that you've got someone who's a vegetarian, we've had cases where that's considered a religion. So it's not just what we think of as the major religions in the United States. The three areas in the fire service where we see religious issues coming up have to do, because of somebody's religious beliefs, they need what's called an accommodation. This makes it different from the other four categories under Title VII. Race doesn't have an accommodation. Gender doesn't have an accommodation. Color doesn't have an accommodation. Or national origin doesn't have accommodation. Religion does. So there may be scenarios where you have to accommodate somebody's religious beliefs. And by accommodation, we mean making some change so that the person is able to do their job, but remain true to their belief system. And where we see this mostly in fire and EMS is with respect to clothing, hair, shifts, and breaks. So clothing, for example, if you have somebody who, as part of their religion, needs to wear a particular head covering, how do we deal with that? If someone needs to wear a yarmulke, or if you've got a woman who needs to wear head covering, how do we accommodate that? And how do we balance it with safety concerns? We also see these cases coming up with hair quite a bit in fire and EMS. One of the things is hair length. If you've got people whose belief systems say, that their hair has to be a particular length, how do we deal with that? And then shifts and breaks. If you've got somebody who celebrates the Sabbath on a Saturday or a Sunday, how do we accommodate them and still let our agency function? If someone needs to take prayer breaks during a shift, how do we accommodate them? 9 times out of 10, these accommodations, are easy to make, with the exception that if there's a health or safety hazard, either to the individual themselves, or to other members of the team, or to the public. But usually you want to see if you can make an accommodation. All right, let's turn to the Americans with Disabilities Act. And you may have heard of this as the ADA. So the ADA, the Americans with Disabilities Act, covers 5 different types of discrimination. Again, people tend to forget about some of these other things. The first category is whether somebody is disabled, but can still do the essential functions of their job. With respect to fire and EMS, this can be a tricky one because there are going to be certain disabilities that may exclude somebody from being a firefighter. Another area of protection is, if we regard somebody as disabled, do we think that somebody has a particular condition? And because they have that condition, we're not going to consider them for promotion, or we're not going to consider them for a particular type of training. It's because we've heard that something may have happened to this person, or because this person might come from a particular religion or a particular national origin where there's a disease, that's more prevalent among that population. Another big thing we see in fire and EMS is we can't discriminate against somebody because they have a history of a disability. Why so important in fire and EMS? And that's because of the number of cardiac events that we have. And so when you're looking at this and you've got somebody coming back to work, it's going to be very important to make sure, one, you've got all the medical information, but 2, that you are not failing to assign somebody or failing to include somebody because of their history of cardiac events. Okay, you want to make sure you do the balancing. Okay, you can't automatically exclude the person. We also have associational disability. Remember, I talked about if you associate, if you're dating somebody of a different race, same thing under the ADA. If you've got somebody who is taking care of a disabled child, for example, which may take more of their time, again, you can't harass or discriminate against that person because of that. And finally, I think the big thing in most of the cases that I've been involved in the fire service are the failure to accommodate cases. When you've got somebody who's disabled, but are they otherwise qualified to do their job? Is there some way we can accommodate them? I think there are types of disabilities that we may not be able to accommodate in the fire service. If you've got somebody who's blind, can they go out on calls? If you've got somebody who is missing a limb, are they able to provide these? Are they able to do the essential functions of the job? But we still have to go through what we call the interactive accommodation process. You still have responsibilities if somebody presents with a disability or a condition. And it's your responsibility to have a discussion about it and find out from the person what the limitations are and compare them to what that person's essential job functions are. You can get medical information from the person's healthcare provider, so you're getting accurate information. And you want to compare it against your job description because, again, what really do you need this person to do, and what are incidental activities to this? And especially when we're talking about volunteers, we need volunteers to fill all different types of activities within our fire service. So we really need to think that through. Talk with the other people in your department, and if there's a collective bargaining agreement in place, You want to make sure that you look at that. What kinds of reasonable accommodations are there? And let me talk about one. A number of fire departments. I've dealt with firefighters who've been diagnosed with ADD and ADHD. In a number of departments, they're excluded automatically if they disclose that they're taking a particular drug. Hence, they don't disclose. Just something to think about. But how could we accommodate somebody with ADD or ADHD? Maybe the limitation is they've got problem writing reports. Is that something that we can have somebody else do? Is that really an essential function of what we need them to do? Are they really good driving? Are they really good doing rescue? Are they really good doing extrication? Maybe we assign the writing to somebody else if they've got that issue. Can we put somebody on light duty if somebody hurt their back? Can we assign them to different things? You don't have to create a light duty position if one doesn't exist. It's just something to think about. And a lot of times agencies get themselves into trouble because they're afraid to consider creating a light duty position, because we think that if we create it for firefighter A, we've got to create it for firefighter B, and then for firefighter C, and for firefighter D. And that's simply not the case. When we do accommodations, it's on a case-by-case basis. So just different things to think about. Okay, but the 5 magic words, what I like to talk about, if you've got somebody who tells you that they've got some sort of condition, okay, your question to them is going to be very simple. How can I help you? How can I help you? Let them give you the information, and then you follow up. Okay, how can I help you? And again, if you're relying on NFPA 1582 for your job description, again, make sure that's official, make sure that's in your documentation, and that'll help you with determining what the essential job functions are for your positions in your department. Briefly, just don't ask anybody about their genetic information. We've got a law on that. I just say that you don't need to know what somebody's genetics are. Moving on, the Age Discrimination and Employment Act. I see we're missing a word there. We call it the ADEA for short. And this protects individuals 40 and over. In 2 states, Minnesota and New Jersey, you have age protection regardless of what age you are. In the rest of the country, it's 40 or over. There is an exception in public safety. Fire departments and police departments can say that we're not going to hire anybody over a particular age. I think with the volunteer and combo, we may not worry about that too much, because if we get somebody that's qualified to do the job, we're not going to be that concerned with the age. But the big thing that I want to talk about is, again, my biggest concern is retaliation. And retaliation is something really bad that happens to somebody after they make a complaint, or, if they were called as a witness in an investigation. And, retaliation, the person doesn't have to be fired. They don't have to be demoted. It doesn't really have to relate to compensation. What it really relates to is someone is all of a sudden being ostracized, or they're being treated differently, or they're afraid to come to work. And it's really that person's aha moment. I never would have reported this if I knew that was going to happen to me. And this is particularly true of people that are witnesses in your investigation, because, 99% of the time, they are obligated under your rules to cooperate in your investigation, and then they're afraid of bad things happening to them. People who make complaints of harassment, or who are witnesses, though, they don't get a free pass against anything bad happening to them. We need to tread a little bit lightly with kid gloves, but the concern is how do you do good personnel management and worry about being charged with retaliation? You can have somebody who you've made a good faith complaint, maybe you did some discipline, but they're really not performing, or they're missing their shifts, They're making mistakes. They're being rude to citizens. And the concern is, you don't want to do anything because they're going to go ahead and file a retaliation charge against you and say, because, this is because I filed a complaint. You still need to be able to manage your people. So we'll talk about at the end, we want to treat people fairly. So if that retaliation complaint does happen, you're going to be able to say, I would have treated anybody the same in this situation, whether or not they made a complaint. And remember about retaliation. Retaliation doesn't just have to, come from management. It can come from your peers and it can come from your subordinates. So it happens at all levels. Something important I want to show you. We've talked about the different types of discrimination. We said race, sex, color, national origin, religion, age, genetic information, and disability. Retaliation is separate. And what this chart shows you of all the charges filed with the federal agency, how many have been filed on the basis of retaliation. So my math isn't really good. I think there were eight different other types of classes, but you can see how most of the claims are retaliation claims. Okay, because it's easier for somebody to prove retaliation than it is underlying discrimination and harassment. And the green just shows you in the past few years that retaliation is over half the charges that have been filed. So that's why it's really important that we're training our personnel how to appropriately deal with people after they've made a complaint or they participated in an investigation. Real quickly, we've got two new laws. The Pregnant Workers Fairness Act. We don't have regulations out on this yet. This is a federal law. Some states, again, like Illinois, where I am, we already have a law like this in place. Because you remember when I talked about accommodations, and I said that under Title VII, the only protected class that got accommodations was religion. Under gender, there was no accommodations. So what Congress did to fill that gap, instead of amending Title VII, they created a brand new law, this Pregnant Workers Fairness Act. So now we have a law specifically that says you have to accommodate people who are experiencing pregnancy, childbirth, or pregnancy-related conditions. We don't know how far this law goes yet. We don't have the regulations out yet. Okay, but regardless of how big you are, it applies to all government agencies. Chief, you're going to speak long?
Listen, can I interrupt, please?
Of course.
We have a question. I think it's appropriate to do it now.
Sure.
Would gender expression include telling a woman to lower her voice? It's not ladylike when she matches the volume level of men, and she does it to be heard.
Absolutely. I call that, kind of subtle discrimination. I actually had a matter in a promotional test where they talked about tone of voice and the language that was used. Anytime you're telling somebody to be ladylike or change their voice, I don't necessarily know if I would do. I would do that to pure gender, though. So to me, it would just be, assigned at birth. And to me, that's sex stereotyping. If you expect women to wear makeup, if you expect women to act a particular way, if the men are always interrupting the one woman at the meeting, that's a form of sex discrimination. If you're always expecting the woman to do the dishes after the crew has had a meal, that can be a form of gender discrimination. So that's a great question, because gender discrimination, is not about the act of sex. It's about how we're treating somebody because of their gender. So great question. Hopefully that answered it. Let me go quickly. Bear with me. I've lost my mouse. Different types of reasonable accommodation, that we've looked at, and this will be in the materials. We're still waiting on regulations. We can put women on leave. Make sure they have water breaks. really important to make sure that they've got gear that fits. We think about after we talk with their doctor, are there particular type of calls they shouldn't be going out on, hazmat calls. So all types of things to think about. And we've got one more new law covering women, the Pump Act for short. It's really an extension of a prior law that was in. We want to make sure if you've got a woman that needs to pump so she can feed her child, she's got to have a private space, a clean space, shielded from view, where she can pump. We make a big deal about this in the fire service because we don't have any extra rooms, and oh my God, the bells are going to go off, and it's really not that difficult to accommodate. Talk with their women. With your women, they're going to have ideas. Other things that I like to do is, if you can make sure, the woman has her own refrigerator, or, there's a mirror for her to use. Just, let's make it easy, because, we want people who want to be in the fire service. And if we're doing these things, we're going to be able to recruit and retain people in the fire service. Just best practices. You've done all these things right, and somebody files an internal complaint, or they goes to the agency. What do we do? And the first thing is, don't panic. Okay, this is just like if you're on, it's the same thing, tactical on the fire ground. Don't panic. Step back. Advise your leadership. Always think about whether there's any safety issues. Has there been a touching? Has there been a complaint made? What are your policies and procedures say? Based on what's been alleged, do we have to take any interim measures? Should these people be working together? How do we do this, especially when we're so leanly staffed? How are we going to do our investigation? How are we going to manage the grapevine, which is the worst? We talk to people about confidentiality and, just really respecting other people. We've got to make sure we resolve it. And the goal of resolution is to take your best steps so that it never happens again. And again, that doesn't mean throwing somebody out of the fire service. It might mean training. It might mean counseling. It might mean some sort of mediation. We want to make sure people aren't retaliated against, and you always want to make sure you have your documentation as to what you did. If you need any extra tools, this is a toolkit we worked on, Women in Fire and National Volunteer Fire Council. It takes you through all these things I've talked about. And the link will be in the separate handout materials as well. But it's got really good checklists in it. So please take a look at it. I like to use some alphabet takeaways, because I know this is a lot of information in 45 minutes. I think the key is always be consistent. If you're treating people the same, and fairly is on the next slide, but if you treat people the same, because remember, discrimination is about treating people differently. So if you're consistent in how you're treating people, that's going to help you in avoiding these claims, or if a claim is filed, being able to defeat it. Okay. Do engage fairly. So it's not enough to be consistent. I don't want you to be an equal opportunity harasser. That's not going to save anybody from a charge. You want to treat people fairly. And these are cases that go to juries. And juries don't care about the law. They want to know if the person was treated fairly. And finally, your 911, get help immediately. Okay. Who are the people in your district? Where should you be going? Or because this is something that you want to address. My contact information is here. Happy to talk to anybody. I won't charge you. Just call and say you're on the VCAS seminar. My goal is to help you out and be safe. And I really appreciate all you do. Chief?
Well, Alyssa, thank you. Wow. Lots of good comments on the chat. Several people going awesome presentation. So thank you about that. But, I shared with the group, be nice, be kind, follow the golden rule. And if you can't say something nice about someone, say nothing. That's in the chat, because it's like it really comes down to that and how you treat people. Chief Brunestini is the one who told us 25 years ago, maybe 40, be nice. And you know what be nice is. But you also, like I now realize that I had a complaint that I had to investigate as a board president, and I did not go back to the complainant because he was not involved in the facts of the complaint. So now I know I should have went back to him and explained to him what it is I did, because we did take action. So
Right. I
I
mean,
would tell. Go ahead.
no, because a lot of the charges that we see is because people think nothing was done. Because the obligation under the law is to investigate and remediate. So, I mean, you may not be going back to the person. I mean, and you're not going to necessarily give them details of a personnel action you've taken against somebody else, but you at least want to follow up.
Right. And a suspension did occur as a result, and so that was not private. People knew that, but they didn't know the specifics. You're right. But courtesy wise, like you said, you should have went and done a follow up. So I'm watching if anybody has any questions. Here's someone from Dan K. Regarding sexual harassment, after it's been reported, what's the best practice while the investigation is being conducted?
Okay, so I know who Dan K is. So, interim measures are really tough. I mean, that's especially when in volunteer and combo, you might be working really lean and mean. And if you've got, two people on it, one person has complained about another person on the shift, are you going to have to put, who do you put on, who do you put on a leave of absence? And let's say it's female complaining about a male. If you put the male on a leave of absence, is going to complain he's being discriminated against, or vice versa. I will tell you, if I ever figure out the answer to that question, I'm going to bottle it and I'm going to retire. It's really case by case, and it's one of the most difficult questions I face when I'm dealing with investigations.
All right, awesome.
I
guess one other thing. I'm sorry. Go ahead.
No,
one other thing I got from listening today is don't ignore a complaint.
Right, and every complaint doesn't mean a formal investigation. Sometimes it can be knock it off or just use be nice. I mean, that's just this is how we do it around here, and we call that bystander intervention. It's pretty simple. So
yeah,
2 words or 3 words hopefully can do it.
Right. And then my final little notes, because I do this. The alphabet takeaways. If all of the attendees don't take and steal that from her, or give her credit at least, and post that in your fire stations and go over those with the officers. You package it all in just a very concise way. If we will do the alphabet takeaways, we will reduce our problems a lot on these issues. So that was a big thing I got from today. So looking for any other notes. So yeah. And maybe the VCOS will make a poster out of that, or I'll make a poster for firefighterclosecalls.com because it's good stuff. So. All right. Any other comments or questions from the group? All right. Just one other, recording is done. Again, if you have officers meetings, and this would be an appropriate thing to use at your officers meeting, VCOS encourages you to do that. Alyssa's already give you her email address so you can get questions answered and free, get some advice from an attorney. And that's always nice. So I encourage you to do that. And then fill out the survey. We want to know what you think. We want to know your ideas. And so we're glad everybody did that. And I want to thank Alyssa for coming on today with us. Alyssa, you have any final comments?
No, I just any questions, let me know. And Chief, I agree with you. I mean, I don't expect everybody to remember all the protected classes and all that. And that's why those alphabet takeaways are really important.
Yeah. So. All right. Well, for all the attendees, again, thank you all for coming. We appreciate it. We had, I saw at least 6 states in the chat room. So usually But as a Nan knows, our IFC coordinator, I lost a guy from Puerto Rico. We've had a guy that he's missed the last 4 webinars. I got to find out what happened to him because it's like he made every one of them for like 4 months. So we've had good representation from around the country as well. So with that, I'm going to bid farewell to everybody. Be safe out there. Take care and go download the alphabet takeaways and post them in your fire station. Bye-bye.